Hello everyone, welcome to Lindalu IP course. My name is Felix SONG, a patent attorney from Mechanical Department of Lindalu and Partners. As we know, invalidating patents is the most common way to avoid potential infringement risk or defend ourselves when someone uses their patents to prosecute us before the court. So, today I would like to talk about invalidity procedure in China. Basically, the whole invalidity procedure in China could be divided into three main stages. That is, acceptance stage, oral hearing stage, and invalidation decision stage. For your better understanding, I would like to give a brief introduction through a flow chart shown on the screen. First stage is the acceptance stage. When the petitioner decides to submit a request for invalidation for a patent, the first important thing we should do is preparing the necessary documents for the request for invalidation, in which invalidation causes, for example, lacking novelty and inventive step, not being supported by the specification and clarity of the claims, and so on, and the corresponding evidence is the most important. After CNIPA receives a request for invalidation, they shall perform formal examination on it. For example, it will examine the object of a request for invalidation, eligibility as a petitioner for invalidation, scope, causes, and evidence of a request for invalidation, format of the documents, and fees. Where the request for invalidation is found not in compliance with the provisions of the Chinese patent law, its implementing regulations or the guidelines after the formal examination and need to be rectified, CNIPA shall issue a notification to invite the petitioner to make a rectification. Where the request for invalidation is deemed not to have been made or is not accepted, CNIPA shall issue notification that request for invalidation deemed not to have been made or notification of non-acceptance of request for invalidation to notify the petitioner. If the formal requirement is approved, CNIPA shall issue notification of acceptance to both the petitioner and the patentee, and transfer copies of the request for invalidation and the relevant documents to the patentee and invite him to make response within 1 month from the date of receipt of the notification. So, please note there are two important aspects not to be missed in this stage. The first one is that the petitioner could also present additional invalidity causes and evidence with 1 month from the date of filing of the request for invalidation. The second one is that the responding to the request for invalidation from the patentee is not a must, but according to the cases we handled, most of the patentee would submit their arguments to the CNIPA. Only in few cases, the patentee would not submit their arguments. Instead, they would express their opinions in the oral hearing directly. Before the oral hearing, the collegial panel for this case will conduct the collegiate examination to understand opinions from both parties and determine the key points need to be investigated in the oral hearing proceeding. Now, let's talk about the second stage, oral hearing stage. According to guidelines for patent examination, CNIPA may, at the request of the parties concerned or in accordance with the needs of the case, decide to take oral hearing proceeding. However, as I know, almost all cases would proceed the oral hearing, and just in very few cases, CNIPA will make the invalidation decision directly without the oral hearing proceeding. In this stage, it should be noted that the consequence that the petitioner fails to appear in the oral hearing proceedings is serious. Usually, the request for invalidation is deemed withdrawn and the invalidation procedure terminates. But for the patentee, the proceeding may be taken by default if the patentee does not appear in the oral hearing proceeding. The oral hearing proceeding is important. The petitioner and the patentee will debate under the direction of the collegiate panel consisting of 3 examiners and explain their reasons. At the end of the oral hearing, the collegiate panel may allow both parties to submit additional statements within a specified time limit, but in which the new reasons and evidence cannot be added. After the oral hearing, the collegiate panel needs to conduct a collegiate discussion and determine the conclusion of the invalidation decision. So here we come to the last stage, invalidation decision stage. There are 3 types of decisions for request for invalidation, which are declaring a patent right invalid in whole, declaring a patent right invalid in part, and maintaining the validity of a patent right. According to our experience, from the filing of the invalidation request to the final decision, it usually takes about 6 to 8 months. Of course, if the petitioner withdraws the request after the invalidation oral hearing, the collegiate panel will usually close the case. Generally speaking, the petitioner can withdraw the invalidation request at any time before the invalidation decision is made. The main reasons for the withdrawal of the request are the invalid causes and evidence are not perfect and need to be further improved. All the parties have reached a settlement. Of course, those who are not satisfied with the invalidation decision may sue in the court within 3 months from the date of receipt of the decision. After this time limit, the patentee or the petitioner has lost the opportunity to initiate an administrative lawsuit before the Beijing IP court. That's all I want to share today. Needless to say, there are just brief introduction of invalidity procedure in China. In fact, there are many other important aspects need to be focused on. For example, requirement to presenting evidence by the petitioner and the patentee, restrictions to amendments of the claims. Due to the limited time, I could not introduce in more detail. If you have any questions, please contact us. As a leading law firm in China, we are always glad to help. See you next time.